Hi, I am Stephen Wenner of Whistle Realty, brokered by eXp, and I've been in residential real estate since 1993. And the most interesting thing about real estate is it's not one size fits all. There are so many nuances, there are so many niches, and today I have the privilege of having a phenomenal attorney that I get to speak to. His name is Oleg Cross. He's the owner of Cross Law PC, trust and estate attorney that also focuses on litigation with probate, or whenever families are having disputes because a loved one or somebody that basically created an estate put you in it, and now there can be disruption. And that's a very interesting world that most people don't think about, so I did want to have an expert in here so that we can discuss the power of putting a trust together, having a legacy that you can actually leave behind, and some of the pitfalls that can actually occur when you think you have your best intentions in mind, but it might not necessarily go that way. So thanks for being here, Oleg.
Yeah, absolutely. Thanks for having me.
Absolutely. So what I wanted to start out with is, what got you into this line of law?
A long time ago, I was asked to serve as a local counsel in a trust dispute here in San Diego. There are a couple of lawyers in San Francisco that were dealing with a large family trust dispute, and they needed somebody here on the ground. So I worked with them on that case, and that was probably 15 years ago or so. And got that trust dispute ready for trial and helped them, and ultimately settled it just a couple of weeks short of trial. And in the process, found myself drawn to this work, and there was just kind of this unique blend of familial values and trust planning and very technical aspects of the probate code and taxes, and also just family values and family wealth and family dynamics. And so I just kind of found myself drawn to it and thought, if I can do this work, this would be fantastic. And I've been doing it ever since, and now I'm a certified specialist in this area, and that's kind of all I do.
And a big thing is, like, a lot of attorneys will just focus on being a trust and estate attorney, but you've also added the litigation piece in there.
Yeah, so I was actually a litigator before I came to trust and estates, and so that's kind of how it found me. And so I've, since, got additional, educational experience, and I also, I create trusts, I create, estate plans. I go through the administration of those estate plans, but I also have always had trust and estate litigation as a part of my practice. And I feel like kind of most people do one or the other, and I've done both, and I kind of feel, being a trust and estate litigator makes me a better planner, and being a planner makes me kind of a better trust and estate litigator in the sense that I understand all these issues that are common in estate plans fairly intuitively because I've done it.
Yep.
And so, yeah, I love this area.
Well, I think what's interesting about having both of those dynamics under the umbrella of trust and estate is that because you're a litigator, you can also see where things need to be buttoned up where maybe other attorneys wouldn't.
Yeah,
right?
Yeah, for sure. And I mean, clients mostly don't think of those as different things. They want to come to a lawyer, sure, and they want somebody to handle all of their affairs. And so they don't necessarily know whether something needs a petition or something, needs a notice of some kind. They just want to make sure that everything's kind of done. And so it's up to the trust and estate lawyer to either do that work or perhaps delegate that work to a colleague. But I kind of see, from a client's perspective, all that being under the same umbrella from the beginning.
Absolutely. And that's where I feel there's misconception in my field as well. Oh, you're going to sell my house, you're going to buy me a house. But there's so many facets of real estate that I've been involved in, that same thing. I can have this dynamic view so that I can help them differently than, let's say, an agent that wasn't necessarily as experienced.
Yeah, absolutely. So, and I love that. And I know, I've known you for a while, and you've helped my clients anytime we just need some information, for instance. You know what the real estate market is like. Yeah. Just by virtue of having some information about a geographical area and a type of property, we can, get that information and use that in a way that's helpful to the client. So yeah, same type of thing. It's a kind of a complete approach to client needs in this area.
Well, let's walk the audience just through the basics, right?
Sure.
And then we'll get to things that are a bit more complex. So the basics of why does somebody need an estate plan is what I would like everybody to understand that may have something of value or something that you want to give to someone or multiple people. Why do you need an estate plan to do something like that?
Yeah, it's a good question. So I've heard one attorney say this, and I've kind of stole that quote from him, that the estate planning is the last tangible act of love for someone other than yourself.
Interesting.
And so it's the last act of caring for someone, whether that's a loved one, and a charity, someone or something that you care about, a pet, et cetera. And so I come, when I initially meet with a client as kind of view neutral. I'm not here to sell you an estate plan. I'm here to find out what the client already cares about, right? And so if they have family members, is that someone they care about? If they have causes, charitable causes or otherwise, is that something that they would like to leave a legacy for? And through that discovery process, we identify what they perhaps need. And so to go back to your initial question, what does someone need? Well, assuming they have, hopefully they have a life that's rich with people and experiences, and they have something that or someone that they would like to take care of beyond themselves. The question is, how do we do that? What's the simplest and most effective and cheapest way of doing that? And in California, obviously, because real estate is typically often part of an estate plan, that usually will mean at least a simple trust. And so that means probably you want to have a simple trust-based plan that avoids probate, results in lower costs for the wealth transfer. And also, part and parcel for what we do is, we take care of death planning and capacity planning. That's usually the first things that estate planners will talk to their clients about. And so the question is, who do you want to ultimately transfer your wealth to, in what manner? And also, who do you want to take care of and who's going to be taking care of you in the event that, if you're in the event you're incapacitated, you're ill, in the event that you're in the hospital. These are a lot of kind of part and parcel for even the basic plan. That's some of the weighty issues that we have to discuss with clients. And they have to think about it, and they don't necessarily always have answers ready for those things.
Yeah, and unfortunately, I think a lot of us don't think about mortality, and the reality of being incapacitated is who's going to now make a decision for you and your loved ones. And again, we don't think of that. It's just such a small percentage of something that can affect us that because it's such a small percentage, we don't want to think about it. We don't think it's necessary.
Yeah.
But, not having a plan, and that's what I would love for you to just elaborate on, quickly, but not having a plan, what can that catastrophe look like?
Yeah, well, you touched on something important there, and that's someone taking care of you if you're ever incapacitated. And as someone who has been in the probate courts a lot, number one thing that I see on the rise is conservatorship litigations. Conservatorships have become an increasingly more important aspect of the probate work. And so to answer the initial question is, well, if someone doesn't have a power of attorney, let's say for property management, for healthcare, one of the first things that may happen is the need for a conservatorship. And so conversely, what is a way to prevent that? Well, with fairly easy planning with your estate planning attorney, you can plan for incapacity and in a power of attorney. You can empower your agent to do all the things that you need them to do in the event of incapacity. And then potentially close the door and hopefully in conservatorship ever being needed. Yeah. And the second thing is obviously probate. So anytime someone dies intestate, meaning without any will or trust, then a simple probate, an outright probate will be open to transfer all of the estate assets through probate administration. And that tends to take a lot longer than people want it to take.
Yep.
And tends to be more expensive than people want.
That's what I wanted to touch on, because again, the general public has no idea how long they're going to be in probate court.
Yeah.
A while ago, they used to say a year. Now it could be maybe up to 2 years from what I've heard.
I think
depending.
For at least in San Diego County, and I don't think there's that much variance statewide, but at least in San Diego County, I feel comfortable saying that even for the simplest uncontested probate, 16 to 24 months is probably optimistic, and that's probably about average.
So what does that mean to them, right? Let's say someone passes away like that. Yeah. They do have to go to probate. What are they going to be experiencing in that 16 to 24 months? Like what, other than, of course, the emotional challenges and just trying to manage and take care of whatever piece the attorney now directs them to, and then waiting for money and posting for creditors. Like, I'm going to be missing some pieces because this is not my profession. But what will somebody actually go through because they chose not to now when they could have, and now they have to deal with the repercussions of never having a proper estate plan done before they passed?
Well, I think the most common thing, I'll try to kind of look at it from what I see as the most common experience, is the experience of, let's say, the surviving spouse of someone who didn't have an estate plan. And so the first thing they're hit with is kind of this bit of shock that even though perhaps, their loved one wanted or would have wanted them to have everything, and maybe that's still going to be the case, none of that's going to happen automatically. And instead, there's going to be this 2-year process. And that initial shock is typically followed by some, regret in the sense that, well, all of this could have been avoided if they had just had like a simple trust done. And now instead for, let's say, the husband's portion of the estate, we're going to have this process where there is a petition filed and there is a publication and there is notice to creditors and kind of having to explain that, we may have to post a bond depending on where they live. And nothing is automatic. Everything is going to require all these steps and a series of hearings. And so even though, we'll walk them through all the legal stuff and we'll appear at all these hearings, all of that kind of creates an undue burden that the client fairly quickly realizes that, oh man, we could have avoided like all of this if we had just done some proper planning.
And that's, my gripe, honestly, in what it is that I do, because I always try to advise my clients to do things correctly, to manage their assets, right? A house is an asset. It's not just a home, or all the other things that they have to take care of. And then there's taxes and other things that people aren't aware of. And that's the other thing I wanted to kind of jump into and have you elaborate on. I know you're not going to call yourself a tax expert, but you're going to know when people need to actually be speaking to a different professional that is going to help them either mitigate some of the capital gains, or will there be a step up in basis on the house that they get and they won't have to worry about that if they sold it?
Yeah.
Like, what do you see, and then how do you advise when things aren't as simple as people would hope that they are, and then it just allows you to be the professional to truly give them guidance and bring the right vendors in their direction anyway?
No, it's a great question. And there's like 3 or 4 different questions in there. But let me start with the kind of stuff that can be mitigated with planning. So for a lot of couples, for instance, marital deduction planning is something that your estate planner can help you with. And that can potentially take care of unnecessary taxes, both capital gains, and also making sure that the applicable exclusion amount, otherwise known as the estate tax exemption, that you either are under that, or there are alternative ways of planning around that. And so the 2 big taxes that we can take care of right off the bat is potentially minimizing capital gains, and also making sure that between the step up and between using the marital deduction, which is unlimited, that the couple can conserve their assets and don't have to pay any unnecessary, estate taxes or gift taxes. So those are kind of like the big 2 or 3. In addition to that, there are other potential taxes that one may, potentially be liable for, and in the course of administration, we'll typically, loop in a CPA to either help prepare a final return, or to advise it with any income tax issues that may be occurring during the administration itself. But that tends to be relatively minor in the grand scheme of things when it comes to estate and gift taxes and the step up. So making sure that you kind of put yourself and your spouse, if you're married, in the best possible position for those big taxes, that is something that you can easily plan for in advance with your estate planner. And that's not necessarily just for high net worth clients. Obviously, the current estate and gift tax, the current estate tax exemption is fairly high. It's $13 million. And even though that's going to revert to basically half of that in 2026, that's still a lot of money. But there are also a lot of simpler things that, for instance, there are a lot of, I see a lot of stale trusts that were created, let's say, 20, 30 years ago, and were perfectly rational for the time being. And, these trusts would create, let's say, ABC trust or decedent's trust, bypass trust, because at the time the estate tax exemption was so low that was necessary for estate planners to do to try to protect their clients from taxes. But what has happened since is the estate tax exemption has gone up so significantly that a lot of those previous trusts are no longer necessary. But meanwhile, let's say if you have a house, and I've seen this time and time again, you have let's say a $2 million house, and half of it is sitting in a bypass trust, is retitled in the bypass trust. Well, so the beneficiaries of the bypass are not going to get the step up because it's in the bypass. It's no longer the estate.
Yeah.
And again, at the time that the original estate planner may have done this, there were perfectly good reasons to do that. But that's not the world we live in now. And so if that can be fixed or mitigated right during the client's lifetime, that could be a significant benefit to either their spouse or whoever the beneficiaries are of that bypass trust. So there are things like that too. So even for an estate where there isn't and is not going to be a taxable estate, you can still help the client, save potential capital gains taxes.
So We've used the phrase step up,
Yeah.
right? And I really want to explain it. But would there be a difference if real estate wasn't in a trust versus in a trust with a step up?
Yes. Well, so
And can you explain step up?
yeah, so step-up in basis is essentially inherited basis. So the beneficiary inheriting the basis that the grantor had at the time of death. So let's say, this can be used for anything. For instance, if grandma had, let's say, Apple stock that she acquired at $100 a share, and the current price is, let's say, $400. The difference in the current fair market value as opposed to the original value is a capital gain. Mm-hmm. And so ordinarily, anytime there's a capital gain that's realized, there's a capital gains tax on that gain, right? However, if, let's say, grandma was to give those shares, let's say, to myself by virtue of a trust, then I can get what's called step up in basis, meaning I get the same basis as grandma had, right prior to her death. And so that would be a significant savings to the beneficiary, to myself, because then I don't have to pay those taxes. So, and there are multiple ways of accomplishing the step up in basis. Trusts are just one of them. Mm-hmm. However, trusts tend to be fairly flexible and, kind of allow us to draft them in a bespoke way, in a way that fits that property. And so that's one way of preserving the step up. Conversely, depending on what kind of trust it is, so for instance, in my example, if there is a bypass trust, because the bypass is the whole point of the bypass is to bypass, to go around the decedent's estate. It's no longer in the estate. And so because of that, because the property that's in that trust, whether it's real property or stock or any other property, because it's no longer in the decedent's estate, it's not eligible for the step up. So what kind of trust you have and where you put there does make a big difference. And so it's up to the estate planner and the client to identify those potential opportunities and say, maybe this property is not the right property to be placed in this trust, right? Or maybe we eliminate this trust and we transfer the property elsewhere. And there are all kinds of potential implications of that. There could be gift tax implications of that. There could be income tax implications if it's income-producing stock. But there are very, very frequently underutilized opportunities that the client may have that they are probably not thinking about. And so kind of the takeaway there is, take that stale trust and that property that's in it and talk to your estate planner and see if there are any opportunities to optimize it. And chances are there probably are.
So that's the other thing, the rule of thumb when it comes to estate planning, and I know you'll validate this, but you need to have your trust reviewed every 3 years because things change, right? You might have bought another property. You might have refinanced a house and forgot to put it back in your trust. There's so many things that can go wrong, but I don't want to just focus on all the things that can go wrong. If, again, you just take what Oleg was talking about a moment ago, he was talking very high level about how he was putting all these puzzle pieces together based on step up or all of these different things. And there's absolutely no way that a typical consumer is going to have all of this information in order to protect yourself, protect your assets, protect your loved ones, protect your legacy, and protect how you want things to go down based on how you feel they should go down. So one of the things that I learned a long time ago from an estate attorney, maybe 7 or 8 years ago, he was saying that there can be performance markers that you write into a trust where if your child doesn't meet such and such a thing, they might not get the money that they thought they were entitled to. Like, you can literally dictate how you want things to happen. And it doesn't necessarily mean it will go uncontested, right? But if you have a great attorney drafting up the documents and you literally lay out how you want your legacy to move forward after you pass, these are the things that can be done. And again, literally, as I was listening and watching Oleg talk and watching his brain kind of put all these puzzle pieces together, I do that in my world of real estate, and that's why I'm an advisor. I don't sell real estate. I advise people on what to do with their real estate and how to get transactions done. But a step up, right? Again, avoiding capital gains taxes. If you want to have a generational skipping trust for whatever reason, right? Like all of these things you would never know existed, or before the exemption went up to 13 million or whatever it is, right? We had the ABC trust. Like you just had all these things that don't necessarily apply in certain markets anymore because things have changed, and there's no way you're going to be able to keep up. I have a family member that likes to believe she's a doctor and, goes on WebMD and checks everything out, or you have people go on LegalZoom and think that they put a trust together until they find out that they didn't. So what I wanted to really, just touch on before we wrap all of this up, because I'm sure that you've come across these things where people might have come in, consulted with you, chose not to, and then came to you and the story was different because something changed, whether someone passed or something like that. And that's what I want people to know, because it's all avoidable, right? So, I mean, if there's something you can share with our viewers before we go, just so they understand the reality of this, because mortality is hitting us all. I don't know when I expire. Nobody does. But when it happens, the real question is, are you prepared? And have you taken care of your loved ones and your legacy and aware where you love them enough to take care of them? Because imagine 2 years of suffering. Imagine 2 years of trying to get your estate in order after someone passes. So, I mean, if you're comfortable just kind of sharing what could happen or things that you've seen, so people get it.
Yeah, no, I have lots of stories, and I'll, kind of try to keep them general. I mean, I've had clients whose loved ones, talked to an estate planner, not me, and then decided not to do anything, and then there was a suicide in the family, and the entire family assets, including the family business, had to go through probate, and it was just heart-wrenching to see that. I've had clients do their own trusts, only for us to realize they were completely screwed up and redo them. I've had clients do their own amendments. Some of those amendments have later been subject to years of litigation in which I've represented clients. So there's lots of, unfortunately, potential pitfalls. I think to bring it back to what you were saying, I think in the best possible scenario is, when the client looks at either myself or other estate planners, they hopefully don't view us as document generators, right? Because there's lots of information online, there's software, et cetera. I think the way to look at your estate planner, hopefully, is that you find someone that you can say, this is a person that, the only other person that cares about my family and my estate planner and my estate as much as I do, or more. Mm-hmm. And hopefully develop a relationship of trust and confidence that's going to possibly transcend even your lifetime.
Yeah.
And that person will hopefully advise you on all these things and make you aware of all the different, changes in the tax law and talk about the changes that you have in your life and your assets, et cetera, and use that person as a guide for you and your family to take care of each other.
Yeah.
I think that's where I would like to probably leave it.
So for the viewers that definitely find this interesting and know that they now need to at least have this discussion, how can they find you?
Yeah, they can find me on my website, www.caltrustlaw.com, or just Google me, and I'd be happy to chat with anyone.
So Oleg Cross, Olegcross. And again, I know there's so much more we can talk about in these scenarios, but in truth, I feel like we covered what people should understand, not just the basics, but they've heard you elaborate on the complexities of what can happen.
Yeah, and hopefully they have some ideas about why.
Yeah,
right.
Absolutely. Yeah. To me, the whys are simple. I know in my life, I've avoided wanting to spend money on something now just because I thought, why? Or, I don't want to allocate it here. But in truth, that small upfront amount to save time, energy, money, and countless, the amounts can be staggering.
Yeah.
Not just to pay through probate, but then if there's an administrator, that person, if they're going to facilitate everything, they're going to be paid basically what you're paid. So you can be paying twice. And what that can do to a family if family members don't feel comfortable with what the administrator is doing or all of these things, again, you will have separations. Things can go sideways. And a proper estate plan, proper planning, proper conversations, an understanding of family up front can save family members, can save time and energy, can save relationships, can save a tremendous amount of money. And time is something you can never get back either. And the amount of time you can save is exponential. Because imagine waiting 2 years while everybody has no idea what's going on and you're pushing and fighting for it.
Absolutely.
So all the more reason to call Oleg. Again, I'm Stephen Wenner of Whistle Realty, brokered by eXp, with my phenomenal guest, Mr. Oleg Cross. Thank you so much for watching, and don't hesitate to reach out to him. He will give you the advice you need.